Here is a long-awaited update on the case that I've got with Janet, the fraudulent TikTok lawyer, who's fictitious, of course. My lawyer and her lawyers went to court. I think it was August 12th, don't quote me on that one, but the judge made her decision on August 13th, and it's big news for us. It's good news. So I'm gonna read it to you guys. Why can't I read shit today? In the Circuit Court of Cook County, Illinois, memorandum and order. This matter comes on the counter-defendant's motion for judgment on the pleadings. The matter having been fully briefed, the court having considered all submitted materials, and the court having advised in the premises, is hereby ordered. Counter-defendant Braun seeks judgment on the pleadings as to Sahi's counterclaim. Braun filed their amended complaint seeking unpaid legal fees on a quantum merit basis for legal services allegedly provided to Sahi. Sahi filed affirmative defenses and a 4-count counterclaim against Braun. The court previously granted summary judgment to movement counter-defendant Braun on count 1 of the counterclaim, in parentheses, fraud, leaving 2 counts of breach of contract, counts 2 and 4, and count 4 of breach of fiduciary duty. Braun also answered the counterclaim on January 23rd of 2024. Braun's motion appears to address only count 4, the breach of fiduciary duty of the counterclaim. Counter-defendant's position is that they are entitled to judgment on the pleadings, as the counter-plaintiff, Sahi, can never plead proximate cause. It is unclear how an argument as to lack of proximate cause affects breach of contract claims where proximate cause is not an element. Under Illinois law, there are 4 elements to breach of claim. 1, existence of a valid and enforceable contract. 2, performance by the plaintiff. 3, breach of contract by the defendant. And 4, resultant injury to the plaintiff. You could have just looked this up on ChatGPT, bro. Gallagher Corp. and Ross 309, blah, 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 blah. Nonetheless, the court will, of course, consider all the parties' arguments. In quotes. In deciding a Section 2615 motion for judgment on the pleadings, the trial must examine all pleadings on file as taking as true the well-pleaded facts set forth in the opposing parties' pleadings and the reasonable inferences to be drawn therefrom. Determine whether a material factual dispute exists or whether the controversy can be resolved strictly as a matter of law. Schaffner v. blah, 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 blah. The court may also consider matters of which the court can take judicial notice and admissions in the record. Okay. If the pleadings present an issue of material fact, the motions must be denied because a motion for judgment on pleadings does not test whether there is evidence to support the factual allegations in the pleading. If well-pleaded allegations are susceptible to more than one reasonable interpretation, the entry of judgment on the pleadings is improper. As mentioned above, a motion for judgment on the pleadings concedes the truth of well-pleaded facts in the respondent's pleadings and all fair inferences to be drawn therefrom. Blah, 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 blah. Braun argues that Sahi alleges that Braun improperly abandoned the Schmuddy-Schmender litigation, leaving her unrepresented and without a path towards recovery. Sahi further alleges that with respect to Schmooface and Schmolta anticipated matters, Braun did not pursue them and left Sahi with no avenue toward doing so. Movement argues that neither of these claims are factually accurate, and so they are entitled to judgment on the pleadings. As for the Schmuddy-Schmender litigation, Movement points to the public record to establish time of its withdrawal and representation. Schmuddy-Schmender litigation is still pending, and there was local counsel. As for the other litigation, Movement argues that Sahi's counterclaim, Sahi raised the prospect of pursuing infringement actions against Schmooface and Schmolta in March of 2021. Braun withdrew less than a month later on April 7th, 2021. Braun argues that while Sahi claimed she lost viable claims, that cannot be considered true. Sahi still retained a viable claim against both Schmooze-faced and Schmolta at the time of Braun's withdrawal. Braun argues that the litigation was in its infancy and the Lanham Act, which controls trademark litigation, does not constitute a statute of limitations, and that the only doctrine of lashes determines whether a trademark infringement action should be barred. In opposition, Sahi argues that the pleadings establish a material factual dispute exists. First, Sahi alleges that Braun improperly abandoned the Schmiede-Schmieder litigation, leaving her unrepresented and without a path toward recovery. Sahi further alleges that with respect to the Schmoo-faced and Schmolta anticipated matters, Braun too did not pursue them and left Sahi with no avenue toward doing so. On the other hand, Braun has alleged that the claims were pursued as evidenced by the invoices and billings attached to the amended complaint. Sahi also goes, so this is the problem, is like the malpractice insurance attorneys were almost trying to make it seem like Braun didn't even do work on the former two cases, like the last two cases, the Schmoo-Face and Schmolta. But Braun's invoices clearly have evidence that she supposedly says that she did a shit ton of work for it. So which is it? Ya baboons. Sahi also goes on to submit that although she had local Michigan counsel at the time of Braun's withdrawal, the counsel was to act as local counsel only. This is like my 3-hour Schmoo-2 video, so I love that. Had no experience as a trademark attorney and was not qualified to handle her case. Sahi also states that she contacted numerous attorneys after Braun's withdrawal in hopes of finding representation for cases no attorney would take them, allegedly due to Braun's filing of this lawsuit and the likelihood of dismissal of a poorly drafted complaint. None of these specific facts have been alleged, but the court may consider those inferences from the pled facts. It is notable that in their answer, Braun alleges that the cause alleged in the counterclaim is a legal conclusion and denies, in parentheses, among other allegations, the allegations that Sahi was harmed. The court has considered the pleadings of the parties and finds that there are issues of material fact, and also in light of Braun's answer, judgment on the pleadings would be improper. The motion's denied. Well, bam. So you guys don't understand, like, she already denied their motion for summary judgment. Then they go through and they're like critiquing all of our affirmative defenses, and then they want to do a motion on the pleadings. Like, at this point, enough. Like, usually you can argue this stuff, like, when you get past discovery, like, just take the depths, man. Like, you don't need to do all this stuff. But I'm so glad the judge, like, saw through all of this, you know what I mean? So we got through basically 2 different types of fraud. I still think the first fraud's there. I have another video coming up on the ARDC complaint, so depending on which one goes out first, you'll see that one too. Janet is Janeting, you know what I mean? Like, there's no other way to put it. She's just, Janet's being Janet. So we just really gotta get through this, guys. I'm praying to God that we can get through this. Now, remember how it was like the malpractice insurance attorneys are kind of like alleging that Janet really didn't work on Schmoo-Face and Schmolta, but Janet's alleging that she has? I think that internally they're butting heads. I think that on that side of the table, they're having some difficulties. And of course, this is like alleged. I don't know anything for sure, but just by how the litigation strategy is so different between the two groups, I can just see that there's tension between them. And they kind of alluded to the fact that, like, they were not able to get a hold of the other two goobers, and, like, they're having difficulty, like, getting discovery on time and, like, doing things, and, like, it just sounds like they're not really communicating very well together. So from my perspective, that's great. You know, it's good that they're not getting along, because having that sort of dysfunction is leaving cracks with what their litigation strategy, even though they're fucking wrong, right? Like, they are wrong no matter what. But That's how I'm exposing Janet's lies over and 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 over again, because they literally can't even like get together and like figure out which lie they want to tell. So that's where they're hurting themselves, because they're just like not even getting along. That's what I think. Obviously, I don't have much evidence on that except for the fact that they're like alleging two things. There's one more thing that is leading me to believe this. On August 27th of 2024, we got an email from the malpractice insurance attorneys, and then they're saying, "Good morning, counsel. Enclosed, please find the following documents. Number 1, notice of deposition issued to Shalene Sahi. Number 2, notice of 206A1 to Sahi Cosmetics. Number 3, subpoena for deposition to," and then it says the owner of Schmoody Schmender. 4 and 5 are subpoena for deposition to people that are from Schmoo-Faced. Number 6, they're deposing a random girl who duetted my video in 2020 saying Schmalta came out with her product first. I can't make this shit up. This random girl who has no knowledge about anything, she just duetted my video and said like Schmalta came out with the product first, which we know now is not true, right? Like, I've literally told you guys this. I've shown you guys, just watch my 3-hour special. I have video of like me talking to Schmalta on the phone, and they also admitted that they came out with theirs way after mine. So why are they deposing a random girl from TikTok? What are they gonna get from that? I mean, I have the DMs. I was DMing her. I was so nice to her. I was like trying to explain to her everything, and then you know, Janet ends up sending her a cease and desist because she won't take her freaking video down. I'm being so nice to her, she won't listen. Janet sends her a cease and desist and was like, "Listen, you're like damaging Shelly's business. You're lying." What the heck? And then number 7, notice of issuance. So that all being said, what does this seem to you guys? Because to me, it sounds like they're going to try and prove that I don't have a case. That my like trade dress case was not real. All of those 3 cases, like I didn't have like a factual basis. Like that's why they're inviting a girl who said on TikTok that Ulta came out with her product first. Like as if she's like an expert fucking witness. That's great. First of all, good luck finding all these people. I don't know how you're gonna get them subpoena to come and find their addresses, so have fun with that. I don't know what their addresses are, so you guys can have fun with that. Number 2, is this just posturing? Or what is this? And number 3, the biggest thing is like, again, it's like Janet and other knucklehead malpractice insurance lawyers. They're not getting along, because if they prove that Janet didn't even have a case in the first place when she solicited me and told me that I have rights and this is my rights, she taught me what a freaking trade dress is, and that these people were infringing on my trade dress rights, and that I was first to commerce and all this stuff. I learned that from Janet. Janet's the one who told me to sue these people. So either way, oh, the fire turned off. My God. Either way, Janet's going to look really bad. That's what I'm trying to say. Either they are dismantling her initial complaint and proving for us that she doesn't have a leg to stand on to bill me even a single dollar. That's what they're going to do. In them proving that I didn't even have a case, they're going to prove that Janet doesn't have any reason to like have a claim against me. Do you get what I'm saying? So it's kind of like they're like, F Janet, it's our turn to pretty much dismantle this entire thing. But the problem is Janet has said in writing and even in the ARDC complaint, they even told me Let me show you what they said. In the ARDC investigation conclusatory email or whatever that they sent me, they said that Ms. Braun basically concluded by writing that Ms. Sahi's infringement cases are good, and I believe she has the winning side. Ms. Sahi is a brilliant scientist, talented makeup artist, and prolific inventor. Her inventions are good and should be patented or protected in some way. So she's saying my cases are good. I have that in writing here. All the times that she was sending me invoices, she kept saying your cases are good. You have your local counsel that can fight this for you. And I was like, no, she literally told me she cannot fight this case. She doesn't have the expertise to fight these cases. So I don't know what you're thinking here. I'm not able to pay you these invoices that you're sending me. So I have it written many times that Janet thinks that I had really good cases. So even if the malpractice insurance attorneys try to do this, they are dismantling Janet's case. And it is very clear by the people that they're subpoenaing to bring these people in that they're going to, of course, the people from Schmoody Schmender and Three Face are going to get up there and say, I don't have a case. Of course they're going to say that. What are they going to say? Yeah, we stole from Sahi. Please, what? So what is their litigation strategy now at this point? I think the girls are fighting. And I'm just gonna sit back and watch with some popcorn because either they fight the case for us and prove that Janet doesn't have a leg to stand on and dismantle that in the first place. I don't know. I'm interested to know what other lawyers think about this. What do you guys think is going on here? I know I said that in my 3-hour video. I know. What do you think? But honestly, I would like to know what other lawyers are thinking. What is their litigation strategy at this point? Are they kind of okay, our fiduciary duty is for the malpractice insurance. F Janet, let's just protect their pockets and their books at this point? Where are we going with this? Because the damages are great at this point. There's a substantial amount of damage that they've done to my business, to me personally. I mean, we're not alleging that in the lawsuit, but let's just be freaking honest here. So it'll be really interesting to see. How this boils down. Yeah, I don't think this is going to go that far though. Honestly, it feels like the girls are fighting, and I don't know how they're gonna fix it. Move forward, So yeah, that is just my little small update on what's been going on so far. It's interesting though. I've been saying, I think we have a really strong case. We can take this all the way through and make sure Janet doesn't hurt any other creators under the guise of protecting our clients. And I would really like to stop her from hurting her other clients the way that she's hurt me. So, and my business, So I would like to take this case all the way through so that we could prevent this from happening ever again. But we need to do the GoFundMe. We really do. We need to do that GoFundMe. We need to take this all the way through. And we have really nice anti-Janet social club merch as well. So please do me a solid and get some merch if you want to get something in return for your donation. All the proceeds for the merch, we're going with Printful. It's print on demand, so it's a little bit more pricier. But it's all going to my lawyer. I really need help because I've already spent so much money of my own on this lawsuit. I can't spend any more. So I really need help seeing this all the way through. And yeah, I would really like to not settle. The goal would be to not settle. But I really need you guys' help raising that capital now. Because like I said, I've already spent tens of thousands of dollars on this case of my own. And it's just too much now for me to bear alone. So if you guys could please help me out, that would be amazing. I appreciate your guys' time. Thank you so much for listening to this update. And I am going to be as transparent as possible, show you guys what I'm going through, especially because you guys are donating to the GoFundMe. So it's only right that you do hear updates and you know what's going on the case and stuff. So I do plan on continuing to update you guys as we continue moving through the good, the bad, the ugly, everything, you know. I'm gonna share it all with you guys. Let's see what happens, guys. Thank you guys so much for listening. I'll see you in the next one, okay? Bye.